Dafeamekpor, because you are, I would say, an interested party, for the lack of better expression, in this case, because you served as legal aid to Ebi Bright, the Tema Central parliamentary candidate for the NDC,
who was earlier. Council.
Yes.
Yes. Interested party. So the NDC.
Who was earlier declared as MP elect.
Yes.
And then last Saturday we saw the Electoral Commission do a recollation and then declare the NPP candidate there, that's Charles Forson, as MP elect. What is the full consequential effect of what happened yesterday, apart from caution the Electoral Commission's declaration on Saturday? What's the full consequential effect of what we saw?
Okay, the effect simply is that the declaration announced by the EC on the 9th of December stands.
That Ebi Bright is MP elect?
That's right. It stands.
But the Mandemus application is still alive and active?
The Mandemus application, I have a copy here. So thankfully we can look at it. Now, if you read affidavit in support of Charles Forson's Mandemus application to the court, and it's an ex parte application, it says essentially that there was no collation in Tema Central, which is a big lie. In fact, he went to court to perjure himself. Now, he did this. First, he wrote to the Electoral Commission in his capacity as a parliamentary candidate, and he narrated these facts. This letter is dated, interesting, he didn't date his letter to the EC, but this is a copy attached to his application to the court.
Right, we have a soft copy, we'll put that on the screen.
Yes, now, he says, I wish to bring to your attention the following infractions, incidents, and occurrences during the collation stages of the process. 1. Collation of the pink sheets began at about 11 p.m. with the presidential and ran smoothly. However, when the exercise was completed at about 4 a.m. on Sunday, the NDC asked for recollation as they have a different total of which the EC obliged. The recollation of the presidential pink sheets were done at around 9 a.m. Sunday. At around 9:30 a.m., all parties agreed for the kickstart of the parliamentary collation. Before the process could begin, thugs from the NDC broke into the center and disrupted the whole program. This is also another fabrication.
Right.
Now, if you get to his point 10, he said the collation process was halted when the NDC tried forcing the EC to declare their candidate as the winner, despite having 2 polling stations pink sheets remaining. This is also another fabrication. Now, in his affidavit to the court, filed on 17th December 2024, he says the following, as part of, it deposed to a long set of facts, but let me quote the essential parts. Paragraph 7, that in accordance with respondents' constitutional mandate, parliamentary elections were conducted on December 7, 2024, in the 276 constituencies across the nation, including the Tema Central constituency of the Greater Accra region. That polls were successfully conducted in all the 148 polling stations of the Tema Central constituency, and results were announced and declared in all the polling stations, and same were forwarded to the returning officer. That in accordance with law, collation of election results commenced on 8th December 2024 at the Constituency Collation Center. It's also another falsity, because collation began immediately the polling station elections were concluded. And results announced at the polling stations and pink sheets transmitted to the collation center at Chemu on the 9th of the 7th. So collation didn't start on the 8th, as he claimed in the affidavit.
I see.
Then, that while collation was ongoing, some young men and thugs entered the collation center, engaging in various acts of violence and threats which disrupted the collation process. Then he says 16, that I'm advised by counsel and believe same to be true that only the returning officer by law can collate, announce results, and declare winners. Yet, at the Tema Central Collation Center, it was the Metro Director that did the collation. Now, paragraph 14 says, following the events narrated above, the collation was moved to the Regional Collation Center on 9 December 2024 for collation to continue. That after a few days, I was informed by the respondent to report at the police training school, Tesano in Accra, with the collation of the results, but I was later informed by the respondent that the collation could not continue. Now, paragraph 17 says that no collation has been done in the Tema Central constituency as required by law. This is also another falsity. Because in Tema Central, we actually did collation, like his letter to the EC narrated. When we began the collation on the 9th of the 7th, when polls closed and results were announced at the respective polling stations, pink sheets were transmitted for collation to comments at Chemu. He brought people to disrupt the process because they are lost. And to the extent that the police had to throw in tear gas to bring the ensuing melee under control. That was when the decision was taken by the police that collation, continuation of the collation be moved to their premises at the Tema Regional Police Command. As I had earlier indicated, the circumstances under which the pink sheets, the ballot boxes were transmitted or moved from the Chemu Collation Center to the Police Regional Administration in Tema was something that we objected to because we don't know who followed those ballot boxes. Now, when we got to the Tema...
Was it the one that they were going to use a private vehicle instead of the Electoral Commission's official vehicle?
Exactly, and I'll tell you, when we got to Tema Regional Police Command premises to continue with the collation, we discovered that, for instance, one pink sheet we couldn't find. We couldn't find it. That's a parliamentary pink sheet. Ofosu Hini had to go back to the office to go and bring that particular pink sheet. What was the pink sheet doing in the office of Ofosu Hini? Because pink sheets are supposed to be put together, put in a ballot box, sealed, before you transmit. It was one of the issues that we took against him. We also insisted that he is not the designated returning officer for Tema Central. So he should allow the accredited officer, who is Mr. Akwesi, as the returning officer pursuant to Regulation 2.3 of CI 127 to do his duty under law. He will not permit him.
So who is the person who did this declaration? What we are showing on the TV now, who is this?
This is the returning officer from Tema West. And if you recall the petition from Ofosu Hini to his principals in Greater Accra, he said that he directed this chap to do the declaration because he did so under duress. As for the issue under duress, I will come to that. Now, after the collation, we objected to the admission of 2 pink sheets. We objected because they were fabricated pink sheets. Fabricated in the sense that the contents on the original were markedly different from the contents on the duplicates we were given. This was the source of the discord. NPP came with Titus Glover, regional minister, came with other office, came with their constituency chairperson, Charles Boateng. The candidate himself was there, Charles Forsen, and a host of others that I'm not able to tell their positions.
Right.
So when they keep saying NDC came there with national officers, they also came with national officers, including the sitting regional minister. That they had issue with the Titus Glover, that go to your office, you have work to do, don't come and sit here and waste your precious time. We had that banter, but it was a friendly banter.
Right.
But they keep refusing point to that fact that they also came with officials from the party. Now, so we disagreed to those 2 pink sheets. Why? Because I discovered that they were written ex post facto the declaration of polling station results. So Ofosuhini was compelled to invite these two presiding officers. They came to admit that yes, indeed, when we close, one said, when we close, we were under pressure. So it was when I got to the office that I was reminded to complete the pink sheets. Because the duplicate that they gave to me contained no name, no signature, no year of elections held, and no time of close of elections, as required by a law, Regulation 39, Sub-Regulation 3 of CI 127. It
was only the results that were...
It was only the results, and the figures were different. You understand?
And there was no signature of the returning officer?
No, but on the original that they wanted us to adopt or agree to, had all these details. So we said, nada, it won't go in. The second one had similar infraction. Again, that presiding officer was also invited. And mind you, it was Ofosuhini who was calling these presiding officers to the collation table. He also came to admit that, yes, it was Ofosuhini who asked him to complete the pink sheet in the office. All these facts he has refused to disclose. And they are captured on video at the collation center at Tema, Regional Police Command.
I see.
So we said, and these two pink sheets favored the MPP candidate. So how do me as a lawyer, I should allow you to smuggle in a material that will hurt the interest of my candidate? Then what sort of lawyer am I? So I said, never, even if we take it to the Supreme Court, never would these two pink sheets make it. Because we had issues with 18 pink sheets. 18. Some were, calculation, miscalculation. No, we allowed them to regularize all those. These are facts he has refused to disclose so far. But for the two, we said never. And we had won the elections. Because if you allow those two, then they beat you. So how would you be fabricating pink sheets in an office with results that will hurt the interest of my party? And when you resist this, they say you brought somebody under duress. We were surrounded by a phalanx of policemen in uniform, in anti-riot control gap, and with guns and all. They provided security. But Ofosuhini insisted. The Metro Director, who is not a returning officer, he insisted that these pink sheets must be admitted. That has always been his position. That was the source of the antagonism. You understand? He didn't say that, okay, then let me declare the results. Whoever has agreed should take it to court. He was insisting because he caused the fabrication of those pink sheets.
I see.
You understand?
Right.
So, essentially, this was all happening in Tema Central.
And for Appiah-Kubi Central, I know you have an idea of how things played out there as well.
Appiah-Kubi Central too had issues. What were the issues? According to Baba Sadiq, they discovered that as many as 31 pink sheets were also fabricated. Why? Because the calligraphy of the handwriting came from the same hand. The nature of the handwriting. Because handwriting is
31 different pink sheets.
31 different pink sheets.
31 different
according to Baba Sadiq, the handwriting, and some judge, the handwritings came from the same hand. Because you see, handwriting, handwritings are peculiar.
Yes.
It's like people can, in a way, change the handwritings, but essentially...
But there are different returning officers for different polling stations.
That's right.
There cannot be
so if you have 31 polling stations with contents emanating from a calligraphic imprint that appears to come from the same person, then you have issues.
But the EC admitted this polling station results on Saturday.
Yes, this were, if a week ago, if you remember, these were the things we were resisting at the police command, at the EC regional office. For instance, I said, even pursuant to the court order that's been panned, the court says go and do recollation. Recollation means retabulate. Ofosuhini won't have it. You saw me on the video. He won't have it. Court says go and retabulate, go and recollate. You say you won't do recollation. You want to continue from where you left off. So I asked him, where did you leave off? Whatever you claim you had left off, You had petitioned your principals in Accra and said it was a process that was fraught with irregularities. So he actually used the language that it should be annulled. Then they give you the opportunity, then you come and tell me that where we were, those two pensions that we were resisting, those are the pensions you want to add. You are not interested in going back because you see, they had also fabricated some. So the conduct, today I want to speak to conduct of public officers. When you are a public officer, just be a public officer. If you want to be partial, if you don't want to be neutral, if you don't want to be a public officer, leave the job. Go and be a party executive and come and do party work. Be a party full soldier. Let everybody know that you are a party full soldier. Or be a farmer like my brother who is now a businessman. You are a businessman as well.
Okay.
But to be wearing EC jacket, when it's used them, then they quote the Constitution and says that in the performance of their functions, they are independent. But in your utterances, you are not portraying that independence. You are portraying bias. When you wear EC jacket, that should portray you as a neutral, independent operator. Your comments do not reflect the content of the garb you put on.
So, but why did the trial judge in the High Court, that's the first case when the mandamus was heard last week, Friday,
yes,
why did he not give the NDC a hearing?
That is a question for the gods to answer.
I'm asking you.
You heard the judge, the Supreme Court, the president of the panel, said that to allow Eduji to speak in his capacity as a friend of the court was not coterminous to giving him the opportunity to represent his clients. The two standings were markedly different.
And the trial judge thought that because Eduji had spoken,
and the Supreme Court did something very important. They noted that in the ruling of the court or in the court proceedings brought before them, they noted that the judge actually recorded Eduji as a friend of the court. That was his undoing. That was the judge's undoing in this matter. That was where the Supreme Court nailed him.
And if he's a friend of the court, then
I can also appear as a friend of the court. But he was supposing to him that we are here on merit. We have an application before you.
But I think there was an application for joinder.
Yes. Yes. So the judge indicated that, yes, I have been informed.
In the case where there was an application for joinder,
yes,
rightly before the judge, he couldn't have come as an amicus.
Exactly. So that's why the Supreme Court got him.
Judge record him as a friend of the court?
That is what I...
Because, you see, the application before him, that's Gary Maku's application, his clients were not named as parties.
They came as party. But as being a proactive lawyer, when you hear things like that, you can actually... Because, you see, the notice, when he says something is on notice to you, is to give you notice. So you can take proactive steps. That I hear there's an ex parte application, but indeed, Bega actually said that in matters such as this, even the court, Suomotu, ought to have directed that let the application ex parte be actually served.
An important history fact. Do you remember the 2008 election? MPP went ex parte
on one Sunday.
One Sunday. So the NDC got wind of it and
we went
to the court. Hey, NDC had not gone there. I thought they wanted court on that.
You know, so these are serious matters. Let me
a quick input from
okay. Yes. It is an addition to a court procedure that ought to inform all courts. In matters like this, it is important that the Judge Somoto ought to have made an order for them to come on notice. And it happens most of the time when you see that there is an interest in the case that is not represented in the matter pursuant to the application.
It's only fair.
It wasn't fair. And by law, or the author, that, oh, please, can you come on notice on this one? So that the other party will also be heard. If you came as party, then the explanation is that even the EC, who was a defendant in that matter, a respondent in that matter, had not been served. You see, and In fact,
AC said they are not opposed. They were playing along.
They had not been said if it was an ex-party application.
But they indicated that they were not opposed to it.
But if it was an ex-party application, so to speak, then one would say that the EC would not be served in an ex-party application. Okay. Nevertheless, the judge ought to have directed that we will come on notice. And in any case, Mandamu's application will not be ripe until they have been served with written communication that you have reneged on this statutory duty and you are by law required to do, and the public institution fails to respond to your warning. It is then that Mandamu's application become ripe.
Yeah, right.
I don't know whether on record all such communication had been shown.
Now, in addition to what Andy had just submitted, you will see that if you look at the application, the exhibits attached to the affidavits in support, you will see letters from these respective applicants. All of them wrote to the EC demanding that they perform this statutory duty.
Okay.
Right.
Now, let me... so, for instance, Eric Nana Jima-Mprempeh wrote. He wrote, is dated 16th December. 16th December. Now, the question is, when did you send this to the EC, such that the next day you were in court? You understand?
Okay.
Now, Charles Forson didn't date his letter, but he also came to court. So they all came to court the same day. But as to the point Andy made that a formal demand was made on a public officer to perform his duty under law or perform a public duty, and yet he failed. So this Tema Central matter, when we came before the regional collation, we demanded that the proper thing be done in law. He won't have it. He had come with an agenda. He had come to insist that those two corrupt pinches be added. Then he was to declare. That was his agenda. He was not interested in what the court had done. The same applies to Baba Sadiq in his case, because they only added those 31 and declared. Because you recall some percentage argument that if 60% of the collations have been collated, then it can be declared. But there's no such authority in law. So clearly, I want to make the point that in ex parte Asare, the Supreme Court is very clear, and Justice Ansah made the point that where results have been declared, the appropriate forum for you is to petition. And the law provides petition. The process is the procedure to petition under Section 20 of PNDC Law 284. It tells you what you should do. But under CI 127, when results are declared, however irregular that may be, it's only a court that is pursuant to, you go to the High Court, pursuant to Article 99(1), I'm sure, Clause A, thereabout. Yeah. That gives you the mandate. So all we are saying is that let the proper thing be done. So for me, the Mandamu's application before the court that we are being asked to go and contest, I know what the legal team can do. Right. For me, I will rely on the Supreme Court decision and not even pursue this matter.
Why?
Because I can say, for instance, that in pursuance of law, the application before the court is incompetent.
Because of the Supreme Court ruling?
Yes, I can rely on it. Yes, it's incompetent. Yes. Then two, I'll quote the law. I'll quote PNDC law, Law 284 for you, Section 20, as a preliminary legal point. That pursuant to Section 20 of PNDC Law 284, this application cannot be entertained. The court has no jurisdiction. I can do that.
I see.
Well,
yes, I can do that.
Supreme Court has directed.
Yes. But I'm saying that as lawyers, lawyers...
But you have a right.
Yes,
but again, the Supreme Court has directed that go back to the instant court. And then...
But let me make the point. Let me finish.
Yes, I think that because of the point you made...
Yeah, but let me finish the point. But I'm saying that alternatively, I'll join properly, like the court said. If it's granted, the joinder too must be heard and granted. And in granting the joinder, it must also be supported by affidavit evidence. I will submit evidence that, contrary to your deposition, that there was, for instance, in paragraph 17 of Charles Forson's application, that there was no collation. Collation actually happened, and declaration officially made. I will exhibit the video recorded.
I see. Per the Supreme Court direction, we have gone to point 0.
Yes. The status quo ante.
Status quo ante.
Yeah.
So there is technically no application before the court.
Thank you.
So at point 0, I would, if I were part of it, I would advise that file a fresh application, whether it's mandamus or whatever.
I think
file
advice
a fresh application and join the other parties, so that you are.
So technically, you are withdrawing the expertise.
Technically,
that's what has been another issue, that the MPP can just go back and withdraw the application.
By practice, once you file one on notice,
bring the parties to court, and this is on notice, and then they will exercise their right either to respond or not to respond.
Yes, well, I agree.
And in the case that they respond by an affidavit in opposition, then they will depose to the facts as they know them. But I want to advise that at this point, we are only just dealing with the application or no application, whether somebody will reapply or not reapply. And whether the pursuant to the application, somebody will respond or not respond.
Yes.
And leave the matters of determination of content to the court, because it will be on evidence. All that the positions and things, but my only candid and small mind's advice is that when somebody makes a deposition, you may disagree with it, but the outright dismissal of it as not correct or not factual or that one, that authority lies with the court. But you may disagree and prefer a counter position to it, and leave the court to make that determination of whether or not there is perjury, whatever. But you can plead to that, and then the court will maybe even address the issue of perjury. But me and you sitting here saying that somebody's deposition is perjurious, I think we should be careful and mindful of how we judge other people, because the judgment doesn't rest with us, it rests with the judge. So,
no, Andy, the point, you see, we are lawyers.
A quick one.
And I have only done what the lawyers do. I have looked at his affidavits. You see, affidavits, they are wittier, because these are depositions on oath. You have deposed on oath that, for instance, there was no collation in Tema Central. And I'm saying you have perjured yourself, because in your own statement to the EC demanding that they come and perform that statutory duty, you indicated that there was some collation. So how do you now go to court and swear that there was no collation? That's the point I'm making. So I'm saying that even with the content of his own affidavit, he's perjured himself. And I can do that as a lawyer. I can also disagree with the content and say that the matters deposed are not factually correct.
Yes.
We lawyers, we say that. Yes, they are not accurate.
But
they are not
when
factually
you
correct.
Become so judgmental.
Oh, how judgmental have I been?
Okay,
my friend, a businessman.
So you reveal the identity of the businessman.
The two of you are talking at cross purposes.
We are not talking at cross purposes.
He says, I'm a businessman. You say that I know a businessman.
Yeah, but that is a long outstanding matter.
Two positions cannot be the same.
I am referencing your new status as a businessman.
Well,
I want you to reveal the identity of the businessman.
Of the businessman you encountered in the past.
What I'm saying is that we are not speaking the same language.
Okay.
No. We are speaking at different things.
Well, in the end, at least there's an oral team member here, so he has an interest in this. If we don't get to know of it today,
we'll
get to know of it tomorrow.
Send me with an application.
No, who's send you the application?
That's fine.
But you do that so